Hey, everybody, and welcome to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel. Welcome to Thursday night. I am back once again. Sorry I missed you last week. Last week is a pretty big week in the Skiba household. My son, got married last weekend on Friday. So Thursday, there was much to do. And so I was helping my wife out. And so sorry I wasn't here last week. But we're back again this week on Thursday night here on the YouTube channel. Again, for those of you who are new to the channel, my name is John Skiba, and I am a bankruptcy attorney and a consumer protection attorney in the state of Arizona. My practice focuses mostly on consumer bankruptcy cases, as well as defending people who are being sued by their creditors. And we also do some plaintiffs type work when creditors completely cross the line to help them out. So what we do here on Thursday nights on the YouTube channel is we do a live Q&A. If you're on YouTube, you can post and I believe you can actually do it on Facebook and maybe even Twitter. You can post a question in the chat section. I'll put it up here on the screen. We'll take a look at it, and I'll see if I can share some resources and some direction. I'm going to warn you up front, my voice is about done. I think the last week between wedding and everything else, it's been a little crazy. So I've got the water bottle here, though, and we're ready to go. My disclaimers that I give each and every week, while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And this is just some guy talking on YouTube. So if you need actual legal advice, if you're in the state of Arizona, my contact information will be below. Feel free to reach out. I do free consultations where we can point you in the right direction and help you and actually represent you. If you're out of the state of Arizona, I recommend you find an attorney in your state who handles these types of cases, so they can give you some specific information. So, all right, we got a lot of questions already. Man, I'm only 2 minutes into this. I feel like I'm already losing the voice. Let's see, one of our regulars here, Monterey MX, says, if the complaint does not ask for attorney's fees, could you discuss whether compelling a jury trial or compelling private arbitration is more effective against LBNV owning a city card debt? So if I get your question right, so we're talking about debt collection lawsuits here. You're asking if they file this lawsuit and it's not asking for attorney's fees, whether compelling a jury trial or compelling private arbitration is more effective. I should tell you this, just because the complaint does not request attorney's fees, at least in Arizona, does not mean that they're barred from trying to seek them. Arizona has a statute. It's ARS 123041 and ARS 123041.01, which allows the prevailing party in civil actions to request their attorney's fees and costs. So if you were to push it to a jury trial and you lost, you could end up with a huge bill. Jury trials would be very expensive. That being said, I can tell you that I know that most debt collection firms, they do not want to do a jury trial. And sometimes that can lead to a better settlement just because there's a huge expense. And if there's any weaknesses in their case, they realize that that people, jurors, are likely not going to have a favorable opinion of debt collectors. And so there is a chance that they could lose their case. And if there is, then they could end up owing you a bunch of money. So it's something that anytime in any civil case, the threat of a jury trial plays into the equation because there's attorney's fees there. I don't know if I would hang your hat on the whole situation, the fact that if their complaint doesn't reference attorney's fees, because they may ask for them, particularly if it goes to a jury trial, and they can amend their complaint if that is a requirement in your particular state. So I think you got to be somewhat careful there. All right. Damien says, hi, John. A while back, I reached a settlement agreement with the CA. According to the agreement, I get 6 months to pay off the debt. Well, it's only been 4 months, and I get a letter from the clerk of the courts on their behalf because I haven't paid anything on the agreement yet. However, the contract only states that I have to pay the full amount and pay the full amount in 6 months. Isn't this illegal on their part? And could I be entitled to damages under the FDCPA, which is the Fair Debt Collection Practices Act? Thanks for your help. So the situation with a settlement agreement, I'd go back, double check the terms. If it truly just says you have 6 months to get it paid, if it doesn't break it down into like monthly installments, then I think you're correct. And the question is, I'm unfamiliar. It's interesting to me. The clerk of the court is reaching out about the settlement agreement. But if they are, if the clerk of the court is reaching out because they haven't made anything yet, I guess it depends on what they're trying to do. If it's something where they're saying, okay, you didn't make any payments on this, so we're going to enter a default, or we're going to set a trial date, or they filed a motion for summary judgment, then I think it's possible there could be a fair debt claim there. In the context of the suit, you'd probably have to file a counterclaim or amend your answer. I guess you could file a separate proceeding. It may give you just some leverage for settlement as well. So I would find out. One, I would just try to clarify it. To me, if you have a settlement in place, worst case scenario, well, I guess not worst case scenario, but one option is if they were going to try to push it to trial or something like that, you could file a motion to the court, a motion to compel the settlement agreement, essentially saying, look, we had a deal here. Here's the terms of the deal. I'm compliant in the terms of the deal. And the court will typically enforce those things. So that may be one option as far as how to get that done. All right. Rini says trial is on May 23rd, and I'm not sure how to proceed. To object: 1, witness's name has not been disclosed or anything other than custodian of record. Says they will disclose. Can't I object to this testimony? In addition, I don't believe they have good evidence to prove their case. How much should I testify? Do I explain everything in detail, or just state that they haven't proven their case? Thank you, Rini, for saying that. I appreciate it. So let me tell you, let's talk about one. To me, it is an issue, and we see this in Arizona a lot, where they have their disclosure statement and they don't give you the name of a particular witness. It just says custodian of records. And that's with good cause for them, because they usually don't know who's going to show up until the day up. Because usually the debt buyers have these professional witnesses. They're custodians of record, and their whole job is they just testify at trials all day long. And so it's just whoever's available will step in and do it. I can tell you this: I've made a big deal out of it before. I have objected to a witness. The rules, if you go back and look at the rules, which, and Rini, I believe you are in Arizona, Rule 121 in the 121 in the Justice Court rules, or 26.1 in the Superior Court rules. It requires that they disclose names of these people and contact information. And so if it's something where, particularly, go back and look at their initial disclosure statement. If they never disclosed anybody's name, and then all of a sudden they show up at trial with some person, what you can do, you can raise an objection to that witness being able to testify. And how that happens is, if they say, okay, Your Honor, we'd like to call our custodian of records as a witness. John Doe is going to come up here and testify. At that point, immediately you can stand up and say, Your Honor, I'd object to this witness. They haven't been properly disclosed. At no point did they disclose John Doe as a potential witness at trial. And you need to bring their initial disclosure statement with you to trial, as well as if they did any type of pretrial statement, to be able to show the court, look, this person's name has never shown up. That being said, I've seen judges allow, particularly just for a custodian of records, because they may ask, well, did you try to take any depositions? Basically saying, does it really matter which custodian it is? The only thing, if they do allow them to testify, what you can do, the way you can take advantage of that, the first question I always ask junk debt buyer, just custodians of record, is I will ask them, when did they review the exhibits prior to their testimony that day? 9 times out of 10, they're going to say they reviewed them that morning. And then I follow it up with a question of when is the last, prior to that, when did you look at them? Often they've never looked at it. Or they did one other time, a couple weeks ago. The reason why that's helpful is because always in closing arguments, I will then say, look, Judge, the person in this room who they brought in to testify as to the accuracy and the authenticity of these documents has spent less time with them than any of us, the court, the attorneys, the defendant. They're supposed to be the expert on this, and they have spent the least amount of time with the documents compared to the rest of us. So that's how I would handle that particular issue. And then as far as if you don't believe they have good evidence, so you've always got to remember the plaintiff bears the burden of proof in the trial. as a defendant, you don't have to disprove anything. You can sit back and kind of just punch holes in their case because they have to show that you had a contract with the original creditor. They have to show that that particular account, your specific account, was transferred from the original creditor to the junk debt buyer. And then they've got to show that their damages, how they calculated the amounts owed. You don't have to prove any of that. And so you can raise the issues that, the evidence isn't trustworthy. You can raise the issues. If you don't have an attorney, they'll likely call you as a witness. But really, I mean, the only thing that you can testify to is maybe the original account. I mean, truthfully, you don't know how they calculated their damages. You don't know how they, if they got the documents, how it was assigned or transferred to them. You weren't involved in that process. And so really your information is pretty limited, although they'll try to use you as the star witness against yourself. So hopefully that is helpful. Let's see if we got a couple more here. Let's see. It says, if you change your address, do you generally have to provide a new physical address to the court, or does a mailbox typically work? Having good luck using your courses so far. Awesome. You need to make sure they have someplace they can mail it. A lot of people, they're surprised, whether it's in the bankruptcy court or even in just regular court, that they expect that everything's done via like either process servers or certified mail. And that's not how it is. They usually just send it via regular mail. So you need to make sure if you change your address, you need to make sure it's the burden and the duty is on you to make sure that they have the correct address. So let's see here. Casey Michael says, I have judgments without trial filed against me. What happens when you don't pay $35 weekly payments for 8 years? I filed a motion to modify for 0 payments. What can happen? I have no income, no assets. If they have a judgment against you and you're not making payments on it, I mean, interest could, even if it's the contract rate of interest isn't accruing a lot of interest, the judgment still does continue to accrue interest. And so if you're not making any type of payments on it, the danger is that it's getting considerably larger. Like I saw one just recently where a $2,500 judgment had been entered years ago, but then it was, turning interest at 30%. And this thing was like $10,000 now, just not even, several years later. So you've got to be careful with that. Al, hey, thank you for the congrats and thank you for supporting the channel. Sincerely appreciate it. Let's see what else here. Back to reading. The judge said that we don't do trial by ambush, and that's exactly right. I mean, that's how you need to bring it up, is that if they haven't, the disclosure rules are there. There's no Perry Mason moments. There's no, haha kind of thing. Doesn't happen. So they've got to disclose it. They've got to give you the names. And when judges are hesitant to do that, I always say, judge, if it was on the other foot, there would be a problem here. And I think most judges will recognize that. So, all right, let's see here. So how does the statute of limitations work moving state to state? Example, I moved from California, where the statute of limitations is 4 years, to Tennessee, where the statute of limitations is 6 years. What statute of limitations is followed by the court? This is a very good question. And it can be a complex question because a lot of it depends on how the local courts interpret the statute of limitations. The courts look at law, that there can be what's called procedural law, which is like the local rules of civil procedure, which just kind of talks about how the court governs it. And then there's substantive law, where the court will, where the actual statutes. There are some states that view statute of limitations as more procedural, and some that view it as more substantive. And usually the procedural law of the state where you live is what's going to be followed. If you have a lawsuit filed against you in the state of Arizona and you moved here from California 6 months ago, they're not going to use California procedural law. They're going to use Arizona procedural law. However, in a situation like this, if you, let's say like in your example, you're in California, the debt goes into default, and you're still in California, and then you move, it's outside the statute of limitations, and then you end up in Tennessee where there's a longer statute. I think you still argue the prior statute of limitations, where the debt was incurred, where the card was opened. And particularly if it expired. If the 4 years has come and gone in California and then you move to Tennessee, I think that's what you argue. And I think you win that argument. I think that not only that, you can look at the terms and conditions of the credit card, and often has a choice of law provision, and it will tell you which particular, which particular law is applicable in it. So, all right. I think I got everything here. Let me see here. All right. I think we got everything. And that is probably perfect timing because I think my voice is about done. And I'm putting together some more videos. Things have been super crazy. Bankruptcies are through the roof, which, I always say is great for bankruptcy attorneys, not great for everybody else. But we've been crazy busy. And so the video schedule, my video editors are asking me like, John, let's get this going. So, but I appreciate everybody checking in tonight. Hey, if you haven't checked it out yet, go look at our link there for Consumer Warrior University. We have a lot of really great people in there and a lot of people helping each other out. You get full access to all the tutorials. And if you're in Arizona, again, check out my information below. I'm happy to see how we could help. Thanks for watching today. We'll check you next week.